Welcome to CCPartners, the employer's choice. We provide expert legal and strategic advice in all areas of labor and employment law. By working closely with our clients, our experienced team delivers pragmatic, proactive solutions, resolving many issues before they escalate. Get to know us better at ccpartners.ca.
Good morning, everyone. Just seeing people entering the webinar, so we'll get started in a minute or two. Thanks to everyone for joining us this morning. Okay, given that we have a lot of material to get through and no doubt some questions and discussion at the end of things, we'll get started and people can join as they can. Good morning, everyone, and welcome to another free CCPartners live webinar. If you're not watching us live, then you are watching or listening to episode 22 of the Lawyers for Employers broadcast, brought to you by CCPartners. My name is Kelsey Orth. I'm a partner here at CCPartners. I'm joined today by two of my colleagues, Arjun and Charles Binns. For those of you who are meeting us for the first time today, CCPartners is a boutique labor and employment firm exclusively advising and representing employers. We are lawyers for employers. When we're not working remotely, our flagship office is located in downtown Brampton, Ontario, and we also have offices in Barrie and Sudbury. We are located online at www.ccpartners.ca. This is also the latest in our focused series of employment law issues relating to COVID-19. So before we do get started, if you have questions as we go, please use the Q&A function at the bottom of your screen, and we'll address as many of them as we can in the Q&A portion at the end of the webinar. Our dedicated articling student, Brandon Lowell, is working behind the scenes to monitor and assimilate all the questions into this. So hopefully we can address as many of them as we go as we can. And if not, we'll, as I said, have that discussion at the end of things. So with that said, if we can turn to the next slide, please.
And Kelsey, before we get started, I know there was one quick question we had come through, just asking about the difference between today's webinar and tomorrow's on construction. So if you want to just differentiate that a little bit.
Sure. Today's webinar is a more general discussion with respect to all sectors of the economy and types of industries and employers, whereas tomorrow is focused solely on the construction industry and the different approaches or considerations necessary for employers in the reopening stages in Ontario. So if you're a construction employer and you can't attend tomorrow, that's absolutely fine. Just recognize that you may want to check in with the materials once they're posted on our website from tomorrow's session in order to make sure that you've got those different considerations and any nuanced changes in mind as well. Thanks, Arjun.
No problem.
So here's our agenda. We've got, we're going to do a quick review of Ontario's three-step reopening plan, which has been accelerated to begin on Friday of this week, much to the delight of patio owners and patio goers, among other businesses. We're going to review Ontario's temporary paid sick leave program, We're going to talk about effectively managing a return to in-office or on-premise work. We're going to talk about refusals in returning to work, talk a little bit about COVID-19 testing practices, vaccine policies, which is a hot and widely debated and discussed topic. And then we're going to talk about how to manage unvaccinated clients, contractors, or third parties attending at your workplace. So as I said, a lot of stuff to get through. We will be able to post a recording of this on our website after, well, it probably won't get up today, but shortly thereafter. So if there's anything that you missed, feel free to come back and listen to it again. And as we said, use the Q&A function rather than the chat function for any questions you might have. All right, with that being said, I will turn it over to Charles.
Okay, thanks, Kelsey. So I think my portion of the webinar today is going to be largely review for a lot of people. At least hopefully it is. If it's not, that's fine too. You can always feel free to ask questions if there's any gaps in your understanding. It also wouldn't be a COVID webinar if at least one of us didn't have a ridiculous COVID haircut. So I'm glad I could bring that to the party for everyone today. So the first thing we're going to talk about here is this Ontario's reopening plan. This is the second or third one that they've announced now. They've done it in various different ways, so it'd be understandable if there was a little bit of confusion about how they plan on doing this. So first, a little bit of history, just in terms of this most recent reopening plan. So the emergency break for the third wave was announced on April 3rd, and then that's when all these restrictions came back in after a brief reopening. And they're all very similar, if not the same, to previous restrictions which were announced earlier. And then, of course, since the emergency break has been in effect, we've come a long way. Vaccination rates have increased significantly, and that's really the focus of the reopening plan from here on out, is the vaccination rates. So just yesterday, I guess it was June 7th, the province announced that this reopening plan, which was originally scheduled to begin on June 14th, would be moved up 3 days to June 11th. So now that's Friday, so we're opening up sooner than anticipated, which is always a good thing. Just in case you're wondering about the technical aspect, so the reopening plan, where the authority comes for these restrictions and how things are going to roll out, you can find in a piece of legislation called the Reopening Ontario, a Flexible Response to COVID-19 Act, and then many of the actual restrictions, if you're concerned about your specific sector, what those specific restrictions are, and how they're laid out in that legislation. You can actually find them in a regulation under that statute, which is Regulation 8820, which has to do with reopening under phase 1 or step 1. I forget exactly how they phrase it. And it has everything laid out, sector specific, how this is all going to play. Another thing I want to mention, in addition to the reopening plan, this might come up a little later, is that the government actually announced an extension to the infectious disease emergency leave, the deeming aspect of that. So for those of you who are aware, there's infectious disease emergency leave, which employees can qualify for if they meet the criteria under the Employment Standards Act. But for those employees who've had to lay people off or have had, suffered a slowdown in work, so people aren't making what they used to, or aren't working what the hours that they used to, the government changed the legislation to deem those employees to be on an emergency leave. And then there was an end date to that, just to make sure that no one was deemed to be terminated and losing their job. They were just deemed to be on this leave, and the government has extended the deeming provision up until September. So again, we might get into that a little bit later. And if you have questions about that, of course, you can answer or ask them in the question and answer period. So you can see here generally this, so the portion on the left, the yellow portion, that's taken directly from the Ontario government, and this is kind of how they lay it out. So there's 3 phases to this plan. The number one factor that they're going to consider in all the phases has to do with the vaccination rates. So you can see here in phase 1, in order to get into phase 1, so to go from lockdown to phase 1, they wanted 60% adults with 1 dose. We have surpassed, I think we're up over 70% now in the province. So that's one of the reasons why they decided to move it up. And then you have these other factors that they'll consider, and they don't get nearly as specific with those. For example, they term them other key indicators, which are hospitalizations, ICU occupancy, that kind of thing. So it's very general, makes it a little bit difficult to predict whether or not they'll move from phase 1 to phase 2. So hopefully they'll be making timely announcements to make sure everyone can adjust themselves accordingly. So again, here you can see just at the bottom of the left there, it's very gradual opening up. So outdoor events and limits on who can be together outside are expanded in phase 1. And as we go through the steps of the reopening plan, it kind of expands from there. So we can go to the next slide, please. So here again, you just have information directly from the government, easy enough to find online. If anyone wanted to look for something a little more detailed, you can see phase 2 here. So you can see here, to get into phase 2, we have to have 70% of adults with 1 dose. And again, I believe we're already there. 20% of adults in the province fully vaccinated. The province has said that they will not consider moving from one step to the next step until at least 21 days have passed. So you can add that kind of caveat in here as well. And then again, you have their general consideration about the key indicators in terms of ICU occupancy rates and hospitalizations and all that other thing. And then again, you just kind of see here, it's just, expanding on step one, the limits for who can be outside go up a little bit, the types of events that you can hold outside go up a little bit, capacity limits at retail stores and other types of operations go up a little bit. It's just a slow kind of iterative process as we go through step to step to step. So on the next slide, again, you can see step 3. And again, here we have the goal of a vaccination rate of 70 to 80% first dose, with 25% of adults in Ontario fully vaccinated. Again, you have the 21 days. We have to be in step 2 for 21 days before the government will even consider moving to step 3. And then they have the consideration of the other key indicators, which isn't entirely clear how they're going to do that. And I think they keep it general on purpose. And I think everyone can kind of understand why that is. So again, you can see here, if everything goes perfectly well, when we get through step 1 in 21 days, we get through step 2 in 21 days, the earliest possible date we can find ourselves in step 3 would be July 23rd, 2021. So I think everyone's hoping that we can do that. And then again, it's just a natural kind of expansion, larger indoor gatherings, larger outdoor gatherings, types of things that you can do will expand. They haven't been specific about what capacity limits might be in terms of indoor operations, whether it's retail or service industry or whatever the case may be. The other thing to note, and I don't think anyone will be surprised by this, is that the government specifically has warned everyone that things change. I think we've all gotten used to kind of constant change over the last year and a half. So this is their plan, but any one of these issues or vaccination rate targets or whatever the case may be is subject to change. We just kind of have to hope that we get timely notice so that we can make the adjustments as soon as we can. So that's the reopening plan. So on to the next slide. One of the things that we've come along with this, and this came a little later in the pandemic, after facing enormous pressure to institute this, the government finally instituted this temporary paid sick leave. Before, you had access to unpaid leave, 3 days under the ESA, and you have that all the time available to any employee. And now they've gone and taken a step. You can see here through Bill 284, the COVID-19 Putting Workers First Act, which allowed for 3 of those days to be paid. And that happened on April 29, 2021. So many of you have perhaps already received claims for paid leave or had to operationalize this in your own operations. So hopefully that's gone smoothly. You can see that the bill temporarily entitles employees to 3 days of paid infectious disease emergency leave and employers with a corresponding reimbursement for any payments made. So the employer pays first, and then they actually apply to the WSIB to get that reimbursed. And you can see, for those of you who hadn't had to do this already, we've included a link to the WSIB application page down at the bottom of the slide there. So if you haven't had a chance to look at that, probably a good idea to just take a couple minutes and check it out and see what the application process is like. So, the obvious question would be, when would an employee be entitled to a leave like this? Because there are some very specific guidelines under the Act that have to be met before an employee will be entitled to them. So essentially, an employee has to be not performing the duty of their position because one or more of the following reasons, and there's 5 different reasons why that would be. So the first is that the employee is under an individual medical investigation, supervision, or treatment related to, in this case, COVID-19. Second is that the employee is acting in accordance with an order under the Health Protection and Promotion Act. So something's happened, maybe they're in an industry or a sector where an order has been made under that act to close the facility down, or something broader than that. So if they're off work for that reason, they would qualify for the 3 paid days. Third is that essentially the employee has been affected directly by COVID. So whether they have it and they're in quarantine, or they're suspected of having it and they need to go get tested and they have to take time off before they can do that. That would be the third reason why they would qualify for this. Fourth is that the employee is under a direction from the employer to stay home for a COVID-related reason. And you can imagine there'd be a number of reasons, it could be an outbreak or suspected close contact with someone, whatever the case may be. It depends on the workplace. And then finally, an employee is providing care to any one of a number of individuals who are listed in the Act for essentially the same reasons as they would be entitled to take the leave themselves. So that's if they're sick, if they're quarantined, if they're isolating, all those reasons. I should mention that this entitlement is retroactive. I don't believe there's any kind of limit on the timeline that employees can actually apply for it. So just because you haven't gotten an application for something yet doesn't mean that you won't get one sooner in the future for 3 days that occurred in the past. And then, so the amount of pay is a little tricky. Essentially, it's the lesser of $200 and either the wages they would have earned or calculation for performance-related wages. So I think for most employers, it's not going to be an issue. It's just the wages that they would have earned for the day. But if you have kind of unique structured compensation plans, or an employee makes a significant amount of money per day, then those issues can be a little bit trickier. Of course, employers can require evidence that's reasonable in the circumstances of an employee's entitlement to this leave. So, you have to be a little bit careful there, because you can't necessarily ask for a doctor's note or anything like that, although it depends on the circumstances. Generally, if an employee can, just give you some sort of document, or they have someone that can vouch for them, generally it's probably going to be good enough for them to be entitled. So you just have to be careful about any kind of requests that you're making there. And then again, last thing, for anyone who hasn't had a chance to look at the WSIB application process, we have a link down there at the bottom, so you can check that out just so you can be prepared. Okay, so we're moving on to the next slide. So again, I think we've all been doing this for quite some time, considerations in post-pandemic workplace. So for those of you who have physical workplaces where employees need to be returning to workplaces, to the physical location, and even for any employers who are able to work remotely, considerations in terms of policies that you have in place, and just how you account or track employee movement in and out of the office. It's all different, and it's all going to be around for the foreseeable future. So as always, keep up to date and ensure compliance with public health guidelines as amended. So no matter where your business is, there's a public health authority website that you can go on to, and they have, in my experience, generally pretty good guidance about what kind of restrictions have to be in place, what kind of extra steps employers have to take to protect employees in the workplace. Consider protocols for accessing the workplace. So whether you have self-reporting obligations, many employers will have employees fill out screening forms, whether they're electronic or physical, before they come in. And then there's record keeping requirements for that. So some of them have temperature screening. It all depends. Kind of along with that, you have to consider what PPE is necessary. So I'm sure for any employer that has been open, they have masks, gloves, face shields, whatever's appropriate for your place of work. If that's not something that you have in place yet, it's certainly something that you want to consider. And then you have kind of policy restrictions, so limiting the number of people maybe that can be in an office at any given time. So if you have, if you need some people to be in the office, but some people can work from home, there should be a policy or a schedule for rotation of employees so that there's no confusion about who can be in the office when and what has to be done if you, for example, you're approaching a capacity limit in a workplace that one of those applies to. Staggering lunches, staggering start and end times, and doing anything that you can to encourage physical distancing, certainly with masks inside, and more and more I see, operations that can operate outside, encouraging masks outside, even if physical distancing can be. So you have to remember too that a lot of these public health guidelines are kind of minimum considerations. You can go above and beyond. You can do anything. You have other obligations, for example, under the Occupational Health and Safety Act. So if it's something that you think needs to be in place to encourage or protect employees while they're working in the workplace, then those public health guidelines are a floor, and you can certainly go above and beyond that to any extent that you want. And then finally, of course, like anything in a legal context, you want to document all your measures taken. You want to have all your policies and procedures posted in the workplace. So if you've had any changes made to policies and procedures on a go-forward basis, you want to make sure that you're making the changes in the policy, you're highlighting them, you're providing them to employees, you're asking them to read and acknowledge that they are aware of the changes. If there are any infractions of those, you want to make sure that you're recording that and you have it all somewhere where it's easily accessible, both for your own protection from a liability perspective, and in case you get for example, a ministry inspection, you want to be able to go to them quickly and show we have, all of our documents in order. Here's all of our policies, all that kind of thing. So, like I said, kind of a review, hopefully, anyways. But it's always good to make sure you're going over these things. And go on to the next slide. So this is just a little more focused on policies and procedures. So this is kind of like what I was saying before. Many of you, I'm sure, had health and safety policies and procedures before. Throughout the last year and a half, you may have amended those. You may not have. You may have just put things in place. So for example, if I know everything's happens quickly, so you may have been in a place where you were reacting and implementing things, but not going back and changing your policy. Well, I think now is the time to review those policies and make sure that everything that is happening in practice is actually reflected in those policies. Whether it's something temporary that could be removed later, or if you just want something more permanent there, it's always nice to have something that you can point to, A, in case the ministry comes around, and B, just to make sure that employees are doing the same thing and that they know what the expectations are. And then, of course, so consider updating and or creating various employee policies. So it's just about considering which kind of policies might need to be updated. So maybe you've instituted a new pandemic policy, that's all well and good, but you haven't touched the sick time policy. Maybe you have some amendments that you've made there for, some employers are extending the ability to use sick time if you're going to get vaccinated, or if you're looking after someone who's in isolation. Those are all considerations for every individual employer, but you just want to make sure that you're updating these policies if you need to. So for particularly those in the service industry, clients and visitors in the workplace, how are you dealing with them? How are you documenting them? Are they doing a COVID survey? What is the survey? Is it different from what employees are filling out? Those are all considerations that you have to take into account. Use and return of company property and equipment policy and work from home policy. So a lot of people are just sent their employees home because they had to, and maybe they've been kind of trying to figure it out on the fly, and they've got something in place now that works. That's good, and then that's what you'd be expected to do in order to react to something like that. But you want to make sure that you're going back now and you're putting it in a policy in paper so that everyone knows what the expectations are going forward. And then of course, anytime you're implementing a new policy or changing a new policy, you have to be doing training on these policies to make sure that they're understood. And that's key to making sure that they can be enforced if they need to be later on. And then finally, other than policy procedures, ensuring employment agreements are up to date for flexibility and things that we've seen as a result of COVID. So first of all, making sure that employment agreements cover things like temporary layoffs. So that if you get to a point where you're being shut down, you have the legal authority to lay someone off. You don't have to rely on the government to amend the legislation again or extend the deemed infectious disease emergency leave like they had to before. You've got something in place that you can rely on. And then there's, I suppose, other issues are, flexibility for terminations. You may want to consider having work from home arrangements, whether it's a policy or it's in a contract, maintaining the right to implement or end working from home arrangements, however you want to do that. So it's not just the policies and the practice in place, it's about thinking ahead, both for current employees and for new employees, and making sure that you have those legal rights in place that you can rely on in case we do end up in a fourth wave and things get shut down again. So with that, like I said, I think that was mostly review, and I'll hand it off to Arjun for contingency plan.
All right, thanks, Charles. And yeah, you ended on the right point with the and I hate that you're saying it, but the fourth wave, I hate to even think about that because we're finally getting into the stage one of the reopening this Friday. So it's tough to talk about a fourth wave, but as we've seen, this has been a very unpredictable time. So I think one of the lessons learned for many employers throughout this pandemic is to plan and prepare for the worst case scenario, while we all sit here hoping for the best case scenario. Employers should never be placed in a compromising situation without the proper planning ahead of time, and that's kind of what we're here for as lawyers, is to kind of help you in the present, but also think about the future. So this is why we actually advise employers to start creating a contingency plan, or a plan B in the event there is a future business disruption. This plan should outline the steps the employer would take in the event of another mandatory shutdown, or a fourth wave, directed by the government or any other regulatory body. We think that doing this will ensure that employers are well equipped should another pandemic or another emergency occur, because we never thought there'd be or at least I personally never thought there'd be a pandemic in my lifetime. We've read about them from 100 years ago, but I thought we were past that. But something else to this effect might happen in the future, and if you have the policies and the employment agreements updated, you'll feel a lot better rather than being caught off guard, as pretty much everyone was during this instance. So, with that said, we finally have the government cutting the red tape, and we all feel prepared to reopen the workplace. But we've had employers come to us and say, the only problem now is that we have one or more employees who refuse to return. So before you move to discipline, or worse yet, terminate, which we've seen a lot of employers come to us say, if they don't want to come back, that's fine, we'll just terminate them. We recommend taking a step back and consider if the employee's work refusal falls under, one of the three categories listed on this slide. So the first thing to consider is this work refusal related to a safety concern in your workplace? So when we're looking at that consideration, it's important to understand that under the Occupational Health and Safety Act, employees have the right to refuse work if they believe there's a risk in the workplace to their health and safety. So generally in the workplace, this involves concerns over the usage of machines or other work processes. However, during these unprecedented times, an argument may be made that risk to exposure to COVID is a reasonable health and safety concern. So in the event of a health and safety related work refusal, employers are, really just required to investigate the concern and follow the work refusal guidelines of that's been provided by the provincial health and safety legislation. That's really your duty under the Occupational Health and Safety Act. So another consideration is, if the employee is entitled to a job protected leave of absence. This is something that requires a larger discussion, and we'll discuss that on the next slide. And finally, a select group of employees may have a legitimate human rights protected reason for being unable to return. And really, no matter what the justification is, your employee's request to be absent really requires a holistic approach. We recommend keeping an open line of communication with the employee to really understand why exactly they're unable to return, and to discuss possible options with them to try to figure out how we can get them back in the workplace. When you're thinking about your duty to accommodate, it really involves considering a request before making a final decision. So this slide lists off the job protected leave of absences that employers should be aware of. And then these are the ones that, you don't really have a choice. If they come to you with one of these listed here, you kind of have to accommodate them, right? So the first one, it goes without saying that anyone that's suffering or potentially suffered from COVID, they must be medically cleared before they can return to your workplace. And this is not only for that employee's safety, but for the rest of your staff and yourself as well, right? So the second one to consider is that, staff may refuse to return, and this is probably the most common one we're seeing, due to child or other family care obligations. This is one of the most common justifications, and we've come across numerous times during the pandemic. And a leave in this regard is actually job protected in many provinces, including, in BC, Alberta, Saskatchewan, Manitoba, New Brunswick, Newfoundland, and of course, Ontario as well. And when it comes to daycares and schools, while they've been allowed to reopen, some have elected to actually stay closed, or other parents have said, they fear sending their children to daycare or child facilities too soon, because, a child goes to the facility, they might be exposed to COVID, But not only that, they might expose the parents to COVID as well, and and on it goes. So it might not be a risk that's worthy in the circumstances. So employers need to balance being compassionate and meeting business needs while remembering that child and family care obligations, they actually constitute protection under the Human Rights Code, under family status. So in this regard, employers are encouraged to consult with the staff member to identify the potential accommodation options, such as a flexible work schedule, variable or part-time hours, anything that you can have the employee come in, feel comfortable, and not just say steadfast, I can't return at all, right? And lastly, when you're considering travel, the main thing to remember here is that employees may still experience difficulties and delays when returning to the company. And it's also important to consider that the 14-day self-isolation is still in place as of today. Personally, as someone who loves to travel, I'm hoping they reduce it to 7 or 3 days so that I can actually go on a trip. But as of now, we're still in that 14 days, and I believe the hoteling is still in place. So there are a lot of hindrances towards traveling. So if someone does go on a trip, you can expect them to be out of the workplace for quite a while. One justification we don't have listed here is that someone might be classified as a vulnerable population. So a staff member may refuse to return to work as they're part of a vulnerable population, if they're if they're a higher risk for severe illness due to COVID, due to an underlying medical condition, a weakened immune system, or age. And this reason actually falls under a job protected leave in the province that introduced job protected COVID-19 legislation. So for these employees, we really recommend taking a really careful approach, right? We recommend providing remote work options, and if anything, bringing them back later in the transition phase. So maybe instead of on Friday at part 1, you wait till part 3 to bring them back completely, when maybe they've gotten their second dose, and a lot of other people have as well, right? But when you're dealing with these people, your real recommendation is to follow the provincial guidelines, because like I said, it's job protected. So they give pretty great guidance on that. And of course, we're always available to help bounce some ideas off too. So now that we talked about what employees can say, let's talk about what isn't considered legitimate. So, and some of these are quite silly, really, in my view, and would be challenging for me to actually take seriously. But so, for starters, staff members who use public transit to commute to and from work, they may be fearful of being exposed to COVID, which honestly is understandable. There's tons of people going on the public transit. There's people who hate wearing masks, and it'd make me worried personally if I was taking the bus or the train. But unfortunately, there's actually no public health advice recommending that individuals avoid using public transit. So, staff members with these challenges are really required to make necessary arrangements to get to and from work. So it's not deemed to be a reasonable justification. And as discussed previously, a common justification we have come across is with people just being, overly concerned of their health and safety. And while the pandemic has caused justifiable fear and anxiety about health and well-being and being around other people, fear alone of potential exposure is not an adequate reason to refuse work. Whether the work refusal is justified will actually just depend on the measures taken by the employer to protect the health and safety and respond to any concerns of being unsafe. So unless the employee has a justified reason other than a really unsubstantiated fear of the virus, you should make it clear that the absolute expectation is for them to return to your workplace. And if they still refuse, well, I would say reach out to us at that point, because this is when things start getting a little dicey. But you'd really have to make it clear that the absence is to be deemed a job abandonment, and it's really essentially a resignation because you have a job available for them and they don't want to return to it, and it's not really justified. Staff members may also refuse to return if they live in a multi-generational household or have, someone who's immune compromised at home, who might be at higher risk if they do contract COVID. So these individuals are obviously fearful of exposing these more higher risk individuals to the virus. But it's important to note there is actually a legislative difference between living with an individual who is considered vulnerable and taking care of them. So whereas living with a vulnerable individual is not job protected, taking care of them may fall under a job protected leave. So, despite it not being job protected, living with a vulnerable individual, we do recommend that employers, just take a practical approach and provide creative options to this employee to minimize exposure, right? You wouldn't want to have someone come into the workplace, contract COVID, bring it home, and you know, kind of have that on your hands. So if there is an option available, we recommend trying to give some remote work or you know, lesser hours, or you know, real staggered hours for these employees especially. So there are general principles we recommend when you're faced with an accommodation request, right? So the first thing to think about is, you know, there's questions to ask: when you can ask, what you can expect to receive, and it really depends on why you're seeking medical information in the first place. So that's really the great first place to step. You need to establish why you're asking for this information in the first place and what information is actually permissible to request, right? So, you know, putting in the circumstance, if someone is asking for a COVID-19 leave, it's pretty obvious that you'll need just information about why they need that leave, whether it's to be taking care of someone who has COVID or if it's themselves who have COVID. And there's actually, in the legislation, which we'll discuss later, there's information that you're allowed to request in this regard. So employees, in this regard, employees don't even really actually know what is available most of the time, and what the rules are surrounding the infectious disease emergency leave. So we recommend that employers be proactive and they seek out information first, so that they are aware of their rights and obligations and the restrictions on what they're allowed to ask for. And this is recommended to be done before or in the process that the leave is requested, because, you know, trying to do so after the fact can be quite challenging. And employers also need to be aware, when not even just with COVID-19, but just in general, when we're talking about accommodation, you're never really entitled to know a specific diagnosis or treatment plan, but you are allowed to ask kind of what's reasonable in the circumstances, right? So in this regard, that employers should always remember that they're only entitled to the information that's necessary to fulfill the duty to accommodate, and to allow them to keep the workplace, you know, hazard free. So you really shouldn't be overstepping. It should be just finding out, you know, if it's justified that they're off, and then what you can do to make sure that it's not gonna, that you're not gonna kind of exacerbate their disability. So there are generally 4 instances when an employer has the right to request medical information, right? So the first is what we discussed previously, is when there's a request for accommodation. So at this time, employers have the right to learn more about the employee's restrictions and limitations. And we generally recommend using something like a functional abilities form or a similar type form, which has really pointed questions and that kind of weave in and out of what you're allowed to ask. And this really allows the employer to get a really holistic view on what is appropriate accommodation to really allow this employee to continue working, and you can accommodate their disability. The second instance relates to when an employee goes off on sick leave, or, you know, on that infectious disease emergency leave. So under this circumstance, an employer may require the employee to provide a medical note from a qualified health practitioner that is reasonable in the circumstances. However, you know, the employer needs to remember you can only ask for certain information in this regard. So the legislation says that you can only ask for the expected duration of the absence, the date when they were treated by the health professional, and whether they're treated or seen by this health professional in person, or, you know, by telephone or otherwise, right? So this obviously in turn means that the employer can ask for information about the diagnosis or treatment of the employee's medical condition. So the other 2 instances listed on here relate to statutory leaves and negotiated leaves. And in my view, they tend to be highly fact specific, and in many cases, they don't even relate to personal medical issues, right? So in these instances, we ask employers to step back and ask yourselves, you know, is my request, is it really going to be considered reasonable in these circumstances? Is it reasonable for me to request further documentation to substantiate the request? And, you know, at this stage, if you're unsure, it's likely best to reach out to your legal advisor, and we'll walk you through how to respond to this absence. So now we'll turn it over to Kelsey, who's going to get into the more nitty gritty on COVID-19 testing and vaccination practices. And I think he's actually going to preemptively answer a lot of the questions that are going to come through very shortly.
Thank you, Arjun. So yeah, let's start with testing practices. With the greater availability, we'll call it, of the rapid tests, particularly, and the government, at least the federal government, making them available, and provincial governments. And in fact, I've seen an email or two from chambers of commerce or boards of trade going around that at least a couple of them are making those resources available to their members, rapid testing kits, that is. When is it reasonable and when should you have COVID-19 testing in your workplace? Well, if there's been an outbreak and you're looking to get people back into work, absolutely makes sense to mandate testing in that case. Likewise, if we're talking about somebody who has been exposed, for instance, you have your screening form and someone answers that they have been exposed, then obviously it stands to reason that they need to return a test showing negative before they can be let back in. And even if they're symptomatic too, you could use those tests. Now, whether you want to be administering those tests as an employer is another question, perhaps. But certainly, at the very least, you can say, "Hey, you need to return a test." And I know, for instance, some of our childcare clients, for instance, would have that policy in place with respect to attendees of the daycares right now, right? If somebody shows symptoms or if they've been exposed and that answer comes in the screening form, then that child is not returning until they've met the requirements, which often require either a negative test and sometimes symptom-free, or the 14-day period being away from the workplace the facility in the case of a client. But it's absolutely reasonable to hold someone out if they do refuse that test in those circumstances, because that's what the government has set as the guidelines, right? If you are showing symptoms or if you have faced exposure, then the public health guidelines dictate that you either get a test or you remain away from the workplace for 14 days. Another element, if you're considering it as an employer, in terms of, especially if you want to administer or have access to rapid test kits yourself, is as a complementary piece to vaccination policies, right? If you have, for instance, if you're in a vulnerable sector, whether that be healthcare or congregate care or congregate living type situation, whether it be a shelter, assisted living, daycare type situations, if there are issues, whether it be a fourth wave or other indicators that the danger is higher once again with respect to COVID exposure, then in conjunction with a vaccination policy, rapid testing or testing in general might be a good option. And we'll talk a little bit more about vaccination policies as we move on to the next slide. So under the Occupational Health and Safety Act, employers are required to take all reasonable precautions to ensure a safe work environment. That's section 25 sub 2H. And then that's, a kind of catch-all provision that says, as an employer, you need to make sure that your employees are safe. As Arjun mentioned, it often, in the context of work refusals, it often applies or is taken to apply generally to, sorry, I've got a note to speak up, and I apologize. I'm usually using a headset, but it's not functioning today. So I will speak up and just say that typically, as Arjun mentioned, in the context of work refusals, occupational health and safety is generally thought of as referring to the processes, machines, that kind of thing that you encounter in a workplace. But when we're talking about a pandemic health risk, it brings it into a new context, right? So the requirement to take all reasonable precautions has to include some type of way to address COVID-19 in terms of risk, exposure, and addressing what happens if it is present in your workplace. Interestingly, Section 26 of the Occupational Health and Safety Act references things that, while not specific to COVID, could certainly be seen to apply in the COVID or in the pandemic context. So at Section 26, we have sections H to K, and those talk about a medical surveillance program for the benefit of workers, safety-related medical examinations and tests as prescribed, so not prescribed here or yet, but it's certainly contemplated. And if prescribed, only permit a worker to be in the workplace who has undergone the necessary examinations or tests. So when they say prescribed, that means that a regulation has to be made. So it remains to be seen whether, like for instance, other immunization requirements that typically go along with, attendance at school, for instance, might be built into our response or our ongoing dealing with COVID-19 in the future. What we don't have from any government, at least in Canadian jurisdictions, is, and certainly in Ontario, a statement saying everybody needs to be vaccinated. We did have, at the end of May, an announcement from the Ministry of Long-Term Care, and the headline from the Ontario government news release said, Ontario mandates immunization policies for long-term care homes. And those three, the three options given under this directive from the ministry were that every staff member had to do one of the following: provide proof of vaccination of each dose. That's one. Two, provide a documented medical reason for not being vaccinated. That's two. Or three, participate in an educational program about the benefits of vaccination and the risks of not being vaccinated. So you still aren't mandating vaccination, but every employer is required to have a policy in order to ensure that it's at least being addressed, right, with your staff. It would be a lot easier for everybody if the government were to come out and say, you know what, we're going to make this mandatory. Vaccination is mandatory, other than the human rights considerations that we're aware about with respect to accommodation. But they haven't done that. They haven't done that for any sector, not even kind of frontline healthcare workers, or even in those long-term care homes. A little bit frustrating, and to many it seems a little bit, counterintuitive that you wouldn't mandate that. But that means that in most circumstances, a mandatory vaccination policy is going to be a kind of an uphill climb for an employer to introduce. You don't have the requirement of the government saying you have to be mandated. So now we're talking about an employer. And referencing the Occupational Health and Safety Act, we're taking every reasonable precaution. That's what an employer is going to say, and we're going to say, and we know that the best defense based on science is vaccination, and the highest rate of vaccination we can achieve. So that's kind of the justification we've heard from employers when introducing mandatory vaccination policies. I haven't yet seen any tested in litigation. Whether they can or not be enforced, in most circumstances, it's going to be tough to justify a mandatory vaccination policy, but that doesn't mean it's impossible. It just, as you see on the slide, it's kind of considered a drastic measure when we are asking people to undertake medical procedures or a medical act as it's defined under the appropriate legislation, such as the Nursing Act. So if we can go to the next slide. Some of the things we can do with our vaccination policies for sure is, Arjun mentioned what we can ask for when asking for medical information. And in this case, there are certainly certain workplace settings where the fact of vaccination or not is going to be relevant, because if you are in a congregate care setting, let's say, and you have employees, some of whom have been vaccinated, some of whom have not been vaccinated, you're going to have different levels of exposure depending on the clients you're working with, potential exposure, I should say. You're going to have those contingency plans or emergency plans that you need to be ready to implement if an outbreak occurs. And in order to know who can do what when an outbreak occurs, you need to know who has the protection of vaccination and at what level they do. So certainly, while you may not normally ask, hey, what have you done from a medical treatment perspective lately? In the context of the pandemic and responding to concerns that arise out of the pandemic in certain workplaces, absolutely, at this point, proof of vaccination is certainly something that employers are going to consider. You see it there, the healthcare, childcare, vulnerable sectors, you can probably have a little bit more leeway in terms of asking for that information than other employers who don't have the necessary or the same kinds of potential consequences, and or who can more easily distance people at work in some of the measures that we heard about earlier in terms of rotating and staggering shifts and more distance in the workplace. Another thing that we can certainly do with vaccination policies is if you're providing time off to receive, whether it's first dose, second dose, you can absolutely require reasonable proof that the appointment has been attended, right? That is the eligibility requirement for getting that paid time off. So next slide is back to the idea of requirements or mandatory vaccination. Like we said, in a lot of cases, you're probably not going to be able to justify it, but that doesn't necessarily mean it's impossible. What are some of the concerns you need to work with? Well, in a unionized environment, you don't necessarily need the approval of the union unless your collective agreement says so. But in developing a vaccination policy, you can expect that the union is going to have something to say. So whether you consult with them up front or get a framework in place and then either discuss or negotiate it, or whether you say, this is how it is and deal with the consequences, you're going to have some kind of union feedback with respect to that policy. You can guarantee it. You have to have, like any management policy, it has to be reasonable under the general concept of the legitimate exercise of management rights. So again, a mandatory vaccination policy might be acceptable if you can demonstrate that the circumstances warrant it. If there are risks with respect to exposure in the workplace, if there are significant risks with respect to an outbreak that may occur or that has occurred. Those are the types of factors that may lead to a determination that it'd be okay. In most circumstances, mandatory vaccination, as I said, is going to be a very difficult policy to uphold, and adjudicators are certainly going to look at the balancing of the interests and the fact that, as I said, there has not been a government decree, even in frontline healthcare, that people must be vaccinated. In the non-unionized sector, you have arguably more flexibility as an employer, but you still need to be conscious of human rights issues with respect to any vaccination policy. And if the legislation doesn't allow it, then you're going to have to justify it the same way you would in a unionized sector based on the specific factors in your workplace. Most office environments would probably not meet that threshold. And again, we don't know exactly what that threshold might be because we have not seen a mandatory vaccination policy go through the litigation channel all the way yet. Next slide, please. Can you terminate someone's employment for refusing vaccination? You're not going to get just cause for a refusal here. Even in a circumstance where you might have a valid or defensible mandatory vaccination policy, a termination for cause for refusing that vaccine is not going to cut it. Even if it's necessary, as we say in some industries, you're not going to be able to say, hey, get this or you're fired. And part of that is because there are other alternatives, right? We have other options, or we are required to explore other options. Like you see in that last bullet point, employees, you could hold them out of work, move them into a different position for a time. Doesn't have to be a paid leave. You can put them on unpaid leave if there are no alternative positions available. As long as you're considering the circumstances and doing what's right for you in the context of your workplace, as well as human rights issues and or any collective agreement issues that may arise in the unionized context. So, for instance, there has been a temporary suspension of not all collective agreement rights, but essentially the allowance for employers to supersede collective agreement rights in certain healthcare settings in response to the COVID-19 pandemic. So while those allowances have been in place, employers have had more flexibility with respect to moving people around in response to COVID-19. And that could apply in the context of moving people around who are not vaccinated versus those who are vaccinated. Again, the biggest difficulty we face is that, and to borrow the phrase that we've all used and heard a million times in the last 15 months, this is unprecedented in our time. And so we don't know exactly how it might shake out in case law. However, we're basing it on the principles that we typically consider when looking at policy enforcement. And we know that it's all case specific and you have to justify it based on your particular circumstances. If we can move on, we've got a couple more slides left before we get into the questions. So I just want to address those briefly. And we've mentioned, or I've mentioned a couple of times, the human rights issue. So as we said, you're not going to get just cause for someone who refuses to get vaccinated. But even before you get to that, if someone's refusing vaccination on the basis of a human rights ground, whether it be a medical issue or religion, then, the next, move forward to slide number 20, please. Yeah. Then you've got a duty to accommodate. And Arjun talked about what the duty to accommodate means earlier, so I'm not going to go into it. But even when you have a valid vaccine or vaccination policy, you still have to deal with your duty to accommodate. And each one of those cases is going to be dealt with on its individual circumstances as well. So always be aware that any policy you have is going to be subject to human rights considerations, and certainly the same remains true for any kind of vaccination policy that you have. So those are the main reasons with respect to vaccination that you would have disability or medical reason and religion. So the last slide coming up then, please, is what do you do for third parties coming into your site, clients, contractors, and what can you ask of them? Can you insist that they're vaccinated or provide proof of vaccination? Well, certainly you've got to have people complying with the screening protocols and any PPE, personal protective equipment requirements within your workplace. Just because they're not your employee doesn't mean they're exempt from your obligations to provide a safe workplace. Where you get into, the issue of what you can require of those people from an information perspective is if your workplace has different standards for those who are vaccinated versus those who aren't, then, and your contractors or your clients are going to be interacting with people within your workplace, then that stands to reason that you can require that information from those third parties. Certainly, if they're going to be working side by side or getting into a discussion with an employee in your workplace, you need to know what protocols need to be followed if you do have different protocols in place. And that may be something that, is in line with your vaccination policy as it develops, as more and more Ontarians receive first and second doses. Again, though, the human rights considerations apply to these service providers or clients. When we say necessary modifications, I think what that refers to is a bit of a lower threshold. Your duty to accommodate somebody coming into your workplace as an outside party is lower than someone who is one of your employees or volunteers or direct clients coming in on an everyday basis. So keep that in mind. And again, it's gonna depend on the specific circumstances. So with that being said, that wraps up the material portion of our presentation. And I know we received a number of questions during the presentation, and I know Brandon has organized those for us. I see one that just came through with respect to making vaccination mandatory for newly hired employees. And so it's an interesting one because, are there different requirements? Can you have different requirements for new employees versus your existing employees? And while I don't think you can make it mandatory in terms of, refusing them employment, there can certainly be conditions attached to that employment depending on the status of their vaccination, right? Whether they perhaps don't start until they're vaccinated or until the pandemic's done. Something like that could certainly be valid. If you have a mandatory vaccination policy for your workplace and it's one that you're sticking with and or has been justified, then obviously you're not going to treat new employees differently. But in terms of making requirements different for newly hired employees, I think it's tough to say that you could deny someone employment on the basis of non-vaccination if you don't have that mandatory vaccination policy as a justified one in place in your workplace. But again, you're going to look at different conditions for vaccinated versus non-vaccinated. And if it's a matter of not being able to employ someone at the time, then that's going to be, again, fact specific.
So I believe everyone can see the slideshow now. This is the first question. And it's a good question, and we've seen it come up. And it's so basically, as we saw in the slideshow, there is now a paid sick leave that they're providing for COVID, which is $200 per day for up to 3 days, right? So the question asks is if an employer offers 3 paid sick days already, are employees now eligible for an additional 3 days? So do you want to take this, Kelsey, or?
Go ahead. I've been talking a lot.
Yeah, sure. So basically, it's kind of complicated, but I would say if you already provide 3 days, then the employee is not eligible for an extra 3 days unless they've already used the 3 days. So if they come into, I think it's April 19th, and they've already used their 3 paid sick leave days for the year, I would say then yes, if they fall under the requirements or the eligibility for the new paid sick leave, they would be owed those 3 paid sick day leaves as well under what they're owed under the WSIB. Whereas if they had not used your entitlement yet, then it would not be an additional 3 days. So like I'm saying, it's quite confusing. I would reach out at that time or look at the legislation. Do you want to try clarifying that, Kelsey? Because I put myself in a loop there.
No, that's okay. I think the simplest way to look at it is that the legislation requires you to draw down any existing employment entitlements first. And so if you provide more than 3 sick days, you're probably not going to get WSIB reimbursement for those days if they go past that. But if you only provide 3, and as Arjun said, they've exhausted those and yet would otherwise qualify for that time specifically related to COVID, I don't think that disqualifies them from these 3 paid sick days and the reimbursement from WSIB in that regard.
Yeah, and I think one important point is that if you provide 3 paid sick days and they use the 3 paid sick days, you can't go to the WSIB after and ask for reimbursement. If it's already an entitlement that the employee had, the WSIB is basically saying that, well, that's too bad. Then we're not reimbursing you for that. It's only if you didn't have that entitlement already, or if the entitlement had been used up already. So let's go to the next one. So for this question, let's read it. So if an employee advises their employer that someone they live with tests positive for COVID and they must now isolate, what documentation can be requested to validate such a claim if they have not received specific instructions from their public health department? So the way I've been approaching this is that, if an employee goes off saying that someone they live with has gotten COVID, so they've been possibly exposed, well, the general mandate is that they also have to quarantine for 14 days. My understanding is that they don't need to receive a negative COVID test after those 14 days because they would have received one originally. So if they have fear of exposure, they would go be tested. I think that's kind of the requirement, to go get tested yourself. And if they have a negative test at that time, then the requirement is only to quarantine for 14 days, and then they're free to go back to normal. Is there anything you want to add to that one, Kelsey?
Well, I think from the employer's perspective, I think I'm looking at it as this question is being asked to say, I don't believe that the employee actually has to isolate and they just want to be away, right? And in that case, I think it's still a matter of, I'm just looking up the specific section here. The evidence of the entitlement, right? Under the leave section, the infectious diseases emergency leave, an employer may require an employee who takes leave under this clause to provide evidence reasonable in the circumstances.
That's one of their favorite phrases in the legislation. It's reasonable in the circumstances, because it leaves it very ambiguous and up to interpretation, right?
So I think, if they've got, I guess, an indication from their, their cohabiter, a document that says their test is positive or something like that, right? It is such a broad clause or a broad provision under the ESA that it's not really an easy one for employers to challenge. But if you wanted to go down that route, I think it would be reasonable to ask for some kind of documentation about a positive test in order to demonstrate that that it's something that's happened. I mean, I guess my question would be why. I guess it's a staffing issue is what you're concerned about. So I'd say talk to us and figure out exactly how you go about asking that question. But there is provision under the ESA to get that reasonable evidence, right?
And I believe my previous answer is going to be to a future question. I mixed it up with the one that I read previously, so we'll see that come up. But yeah, I would agree with Kelsey that reasonable in circumstances is likely. If you're saying that the person you live with has COVID, we just need some type of proof that the person in reality has COVID, and that might just be in the way of a screenshot of the positive COVID test, right? It'd be hard for someone to argue that that's not a reasonable request, considering they'll be off for 14 days, right? So how can I add temporary layoffs to my employment agreement if they don't already exist? So I'm assuming they mean the employment agreements don't exist, Kelsey?
I'm guessing they don't have a clause in there about temporary layoffs, and so that gets into a whole discussion about constructive dismissal. Obviously, probably not ideal for the context of this particular webinar, but a brief discussion of constructive dismissal is, as you've seen with some of the cases around COVID, if you don't have the right to lay someone off just because it's in the ESA doesn't mean you can do it, right? So If your employment agreement doesn't provide that right to put an employee on temporary layoff, then that has been found to be constructive dismissal at law, absent any consideration of the infectious diseases emergency leave. So to get it into an employment agreement, you have to provide consideration. If you're talking about a new employee, then it's simple. You just revise your employment agreement. If you're talking about existing employees, you have to provide them with either reasonable notice of a change of a fundamental term and condition, or financial consideration for accepting that change. So those are the two ways to do it. And again, I'd say ask us and we'll help you with that. So that's kind of the quick and dirty version of that answer.
And like Kelsey said, we could probably spend a whole webinar talking about, adding provisions to agreements, whether they're existing or new, and what should be added and how to do it and how to approach that. So that's definitely something you should reach out about. It's definitely a great clause to have in the employment agreement. It goes back to what we discussed earlier with contingency planning. It's funny. I was speaking to Brandon before the webinar, and I was telling him, I think I had practiced for about 3 years before COVID hit, and we had temporary layoff clauses in our agreements, but I always had employers tell me, we could probably just get rid of those. I never do temporary layoffs. There's no real need for it, right? And at that time, I never agreed really, but I always thought to myself, I don't think I've ever actually helped an employer with a temporary layoff, at least in the employment setting. On the union side, in the labor side, you see it a little bit more, but with employers, you don't see it very much. And then COVID hit, and now is helping employers do hundreds of layoffs, right? So you never really know when these provisions are going to help you. But now we've at least seen a case study where employers that didn't have that clause were really left, holding the bag really. So it's something we definitely recommend adding in, and as you plan for the future.
I would say on the subject of employment agreements, there's a great podcast available under the broadcast tab of our webpage. Episode 5 of our Lawyers for Employers podcast is called Employment Contracts, aka Every Employer's Best Friend. You know what, we'll probably do an update on that sometime in the not too distant future, because the law is always evolving in that area as well.
And what you learn is that employment lawyers love talking about employment agreements, so it's a very natural topic for us to discuss again. So you can look forward to that soon. So the next question we have is it a protected leave if the employee won't return due to childcare obligations, stating they don't have daycare, but daycare is available and the employee chooses not to enroll them until this fall? Kelsey, as the daycare king, he can speak to this question.
To me, that's not a protected leave, right? The protected leave under the Employment Standards Act is when something is not available. Personal choice is a different issue. Now, does that mean as an employer you necessarily want to enforce that? Maybe not, but you know what? Personal choice is personal choice, and choices have consequences. That is perhaps a harsh statement, and you don't necessarily have to put it to that employee that way. But in terms of strictly answering the question, no, that's not a protected leave, because the options are there, and it's not a forced hiatus from childcare or a government shutdown, such as we saw earlier, or and currently are experiencing with respect to the school age childcare clients.
And I think that's the key there, right? Where if there was no other option for these people, then you say, then it would be a protected leave, right? Because that'd be covered under family status. If they have no other option, where do these kids go? What do I do with them? I don't have anyone else to care for them. Then yeah, that seems protected. But if there is an option available, like in this question, if the daycare is available, then them choosing not to send them there is their decision. So to us, that's no longer job protected. So the next one asks, if an employee refuses to return to work because they don't feel comfortable sending their child to summer camp program with this, so it's the same as the last question, it would not be job protected. If these summer camp programs or daycares are available, then it's really, and that's kind of what you would say, right? Like it's really about having a discussion with them, saying that, we understand that these programs are available to you, and we recommend that you use them. If they say no at that time, then you start getting into a discussion about what's reasonable, and you try, because you're making an effort to accommodate. But if they're not willing to participate in the accommodation process, then they failed their duty on their end, because it's a two-ended spectrum, right? It's not just the employer who has to provide the accommodation, the employee has to participate as well. So if they're being unreasonable, then it's it's very fair to say that it's no longer job protected.
Yeah, and I think that same point can be made with respect to the idea of, if we go back, the slide references, the slide 10 about refusals to return to work. And I think what they're talking about is it mentions caregiver duties for families, possibly in respect of the job protected leaves, but I think you also have to look at it from an accommodation perspective generally under the Human Rights Code. Would it qualify from a family status perspective? And again, I don't think the answer is that it does here, because there's nothing, and family status is a really difficult issue to deal with under the Human Rights Code. But in a general sense, essentially not having childcare arrangements by your own choice is, to me, not enough to get you that family status exemption or accommodation either. So just wanted to address that. I mean, similar outcome, slightly different lens on it.
So if you have an employee who has a doctor's note allowing them to not wear a mask, can the landlord of your office tower still mandate masks and not allow that employee in the building if they cannot wear a mask?
So I think what you'd have to have here is a discussion with that landlord to say, look, we've got an exemption here, and we have to figure out a way to accommodate. So that because your landlord is not liable in the sense of, from the employee, but by the same token, if they're not complying with their obligations in terms of service provision, and I'm thinking this on the fly here under the Human Rights Code, employment is not the only area in which there are prohibited grounds of discrimination. And so if that qualified as the provision of services and they're discriminating on on a protected ground there, they'd have to deal with that. So I think, you'd have to have a discussion with them about procedures and protocols in terms of being able to accommodate that employee. If it's absolutely, if having had that discussion, it's impossible to accommodate them, then it goes down a different road in terms of what that means for you as an employer. And I think we'd have to talk specifics at that point.
Yeah, I think it's really no different than when someone doesn't want to wear a mask or someone is medically exempt from wearing a mask going to public places like a grocery store, right? Is a grocery store under the obligation to accommodate this person? And I believe they are, if there's an actual medical exemption. So I believe that the landlord would not be allowed to disallow someone to wear a mask if you spoke to them and you made it clear that this person is medically exempt from wearing a mask. So this really is a case specific circumstance. We would definitely assist the employer throughout this process. I can say I haven't seen this happen yet. And it makes it challenging because you're talking about three different individuals, right? You have the landlord who has their own rules, the employer who can have their own rules, and then the employee who has a medical exemption that goes against most the general sensibilities. So yeah, definitely reach out if you're actually facing this issue, and we can do a bigger deep dive and really speak to you about the circumstances related to this. But that's kind of our first look at that. So this is the one I meant to answer earlier. Does the employee who has been quarantined for 14 days due to exposure need to be tested prior to return to work? My understanding is that they don't. If they've done the full 14-day quarantine, then there's no requirement to be tested, unless I'm incorrect, Kelsey, if you know off the top of your head.
No, that's my understanding as well. The testing allows one to come back sooner. I mean, that's been the guideline from the beginning, is 14 days, and if you get tested and you're asymptomatic, then you can come back sooner. And obviously guidelines and expectations have changed at various times over the pandemic, but that's still my understanding with respect to the 14-day quarantine from last exposure.
Okay. So I think that's the end of the questions. unless we have any more come through, we can give it a minute or two.
So I see, Lisa, you've asked, I guess, a follow-up to the building question. I don't know what a bando is.
I'm assuming maybe like just another like a face covering, a less restrictive face covering. I think what she's trying to say, like a bandana. Yeah, she's saying.
Okay. Sorry, I'm not up with the lingo, I guess. Yeah, and that would be something to discuss with the landlord, right? And determine what is, what's an appropriate accommodation, and again, the context of accommodation requires you to consider the safety to coworkers and other, users of the space, as well as cost, right? So maybe that would be an appropriate accommodation. I think we'd need to get into some specifics before offering, a pronouncement as to whether or not that's appropriate.
Yeah, I think it comes down to discussion with the employee as well, right? Where it's, you're not asking why they can't wear the mask, but you're asking what they're willing to do. Because I know even in our workplace, I think that even if someone had a medical exemption to not wear a mask, there would be a level of discomfort around it. Like everyone's been trying very hard to socially distance and wear their masks in public areas in our office. So a medical exemption or not, there is just a general approach that you'd expect. So you can speak to the employee and see what they're willing to do. And I found in most circumstances, if you're willing to make an accommodation, employers are generally willing to be quite reasonable as well. So it's that's why it's important to go in with these things with an open mind and really try to find a compromise. So I think that's probably all the questions. If you come up with any more after the fact, feel free to give any of us an email, or our emails are right here. And we'll be sure to get back to you. And if it's case specific, we can always schedule a call. Otherwise, I want to thank everyone for coming to the webinar today. It's been a treat.
Yeah, and I'll give the usual plug to follow us on social media. We're on Twitter, LinkedIn, Facebook. We have a YouTube channel where you can watch our various video broadcasts, and we have podcast versions of this episode, as well as all of our Lawyers for Employers broadcasts. You can find those podcasts on SoundCloud, iTunes, Google Podcasts, or, as they say, wherever you get your podcasts. Thank you very much, everyone. It's always a pleasure to have these discussions, and we look forward to the next one.
And I know Kelsey alluded to it at the beginning of the webinar, but we do have another one tomorrow for construction-specific clients. But obviously, anyone's welcome to join that if you have some questions in that regard. So we look forward to seeing you there as well. And have a great afternoon.